ERISA has 5 fiduciary definitions. 4 of them are crystal clear, and the 5th is vague and dangerous. And it's the one that people like you get sued for, even if you did everything right. In this video, the WILDCARD fiduciary definition in real lawsuits, why more fiduciaries means more personal risk for you, and how one major mutual fund company triggered a lawsuit storm and let fiduciaries take the fall. It's one thing to describe a car, it's quite another to see it on the road. Same goes for fiduciary lawsuits. So let's take a drive and see how ERISA's definitions play out in the real world of court. Every 401k lawsuit names at least 2 defendants. One is the employer and 1 or more individual fiduciaries. The employer is named because it created the 401k and most likely serves as its administrator or trustee or both, filling 2 of the fiduciary designations. The individual fiduciaries are named because they have or exercise authority over the plan. These are the individuals who have personal liabilities as described in ERISA Section 409. As an example, a few years back, the same law firm sued a dozen institutions within 3 weeks on the same grounds. But the individual fiduciaries varied greatly. One lawsuit named just 1 individual fiduciary, another one named 5, another one named a dozen. Curious, right? So I've asked 3 questions. First, what did these institutions do that got all of them sued for the same thing at the same time? And the answer is a poorly performing mutual fund. Plaintiff lawyers found out about the fund and targeted these big 401k plans using it, dragged the fiduciaries into court. Fiduciaries are told that big-name mutual funds protect them from lawsuits, but in this case, they were the magnet for the lawsuit. So our first real-world observation is that relying on brand names can get you in deep trouble. The funds don't get sued, you do. Surprise, surprise. Second, why did the same law firm choose to sue 1 fiduciary and 1 sued 5 and another and a dozen and another? It came down to how the company conducted its 401k fiduciary decisions. One had a centralized decision maker. Others had multiple people making decisions. The fiduciary definition in ERISA that says authority creates a fiduciary means that the more people you have making decisions, the more fiduciary defendants you're going to have. Third, does having multiple fiduciary defendants spread your monetary risk out among all the fiduciary defendants, or just trampling all their risk back onto you? Well, the answer is the more fiduciaries you have, the more likely more people will be sued, and the co-fiduciary liability rules applied. Now, I'm going to get into that in detail on another video, but just for now, you're going to get dragged into their lawsuit. And if you've got multiple people making decisions, you might want to rethink that strategy. Now let's look at 2 common 401k features that sound helpful, but can actually increase your liability. About 15 years ago, a new idea for reducing fiduciary liability became popular. 401k fiduciaries were advised to get an investment policy statement, or IPS, to reduce the opportunity for a plan participant to sue for not being fully informed. Sounds great. It's not. I was in the investment business when the idea for an investment policy statement began to be promoted. Guess who promoted it? The investment companies. They offered to provide a free policy statement and be your pal to close down that risk. Now, do you think the language in the investment policy statements benefited the investment companies? Like, did the commitments that you make in an investment policy steer business to the investment company that provides it, steer business away from them, or be completely hands-off? And before you answer, if it steers business away, how long do you think the person whose idea this was would keep their job? And if it's completely neutral, why would they bother taking the time to write it, promote it, do all that stuff? Free, here we have it. The answer is the policies in the investment policy statement are designed to eliminate competition under the pretext of protecting you. And there's a downside, and I think it's a big one. What if for some reason you don't like the policies? What if you forget? What if you make a mistake? What if the investment markets change? Well, you promised. And in the eyes of a plaintiff lawyer, that's just too damn bad. It's your problem and you're going to pay. Now look, you've got no place to hide here. If you're sued, you lose. The only safe way to use an IPS is to make sure it says it's a guideline only, not a rule book. You must retain discretion based on current circumstances. If you already have an investment policy statement, you need to get that language in there that says you can change your mind at any time. And if you don't have an investment policy statement, don't start, or don't start without that language. Now, once investment policy statements became popular, the next big idea from the investment company was to have a 401k investment committee. In the blitzkrieg of lawsuits I mentioned earlier, the reason for the number of different fiduciary defendants was investment committees. Under the WILDCARD fiduciary definition that anyone who has or exercises authority is a fiduciary, it looks like investment committees are chock full of fiduciaries. And I have a couple of questions to ask you now, while it's safe, that a lawyer might ask. Do you have an investment committee? And you say, yeah. Lawyer asks, do you get advice on which investments to use? And you say, yes. And the lawyer says, how do you justify this? Taking investment selection advice from a committee of people who are not in the investment business? And you go, well, I don't really listen to them. And the lawyer goes, well, why do you have a committee in the first place? And you go, well. Now, look, I'm laughing now because, honestly, you're setting yourself up. I don't see a good way out of this. It's about as wise as appointing me to the Food and Drug Administration's Drug Approval Committee. I don't know jack sprat about that. My niece does. She's a math wizard, statistics genius, has traveled all over the world with conferences on how to get drug approval through statistical requirements. She could do that, not me. So just because someone takes pills doesn't make them a pharmacist. And just because somebody has a 401k doesn't mean they know jack sprat about investments. You pay a broker or agent or advisor to help you select investments. How about listening to them? That's what you're paying them for. Investment committees and investment policy statements do not make you safe. They are deceptive, manipulative, and risky because of their ability to boomerang more risk onto you. Now, I spent decades in the sales end of the investment business, and it's my opinion that the great majority of salespeople with whom you interact want to see you do well. It's a win for you and a win for them. The promotion of investment policy statements and investment committees didn't come from salespeople in the field. It came from the managers, lawyers, and marketing people who pride themselves in bringing in more business at no risk to their company. And if you, the fiduciary consumer, suffer a greater risk, that's your problem. Buyer beware. So please don't blame the salespeople you're working with. By the way, if you were introduced to these videos by a salesperson, keep that relationship forever. Obviously, they're concerned about you. It's just that on these videos, I can say stuff that they can't. Remember, you are the primary person sued. You take the hit, and your primary duty is to avoid getting sued. What sounds helpful may actually hurt you. In the next video, we're going to look at ERISA's co-fiduciary rules and how that liability gets spread around or dumped back on you. You don't want to miss it. And you can see that video by clicking here.